Hello everybody and welcome to this second of our two webinars with Specialist Housing Barrister and Deputy District Judge Robert Brown. Hello Robert.
Hello Tessa, good morning, and hello to all of you joining us on this webinar. It's a lovely sunny day to be stuck inside doing a webinar, and we did one of these last week covering issues about letting during the current pandemic and regulations and so on that have been issued, and we thought it would be useful to do a second one about going to court, or not going to court as it might be. So that's what we're going to try and do. So yes, I'm pleased that we've been able to set this up and hope it can be useful to you.
Right, before we start, just a couple of housekeeping things. As you can see, Robert's done a PowerPoint presentation which is available in a PDF version. If you're on the live webinar, you can download that from the handouts. There's a handouts thing which should be on your screen. Don't worry if you're not able to download it, or if you're listening to this afterwards, because I will make it available on various blog posts on Landlord Law and on the Landlord Law blog. Or if you can't find it, just send me an email and I can send it back to you. If you've got any questions, Robert will be taking questions. If you could probably put them in the Q&A, although people tend to put them in the chat as well, and then I'll chip in and ask them to Robert at various times. We may not be able to answer all of them, but we'll answer as many as we can. So anyway, thank you for coming, and over to you, Robert.
Great, thank you very much, Tessa. Yes, and as Tessa says, I can just reiterate that. Please do ask your questions in the chat or Q&A, and we'll deal with as many as we can as we go through. So, as I say, we did a webinar last week, and this week we are moving on to look at 5 key topics really about going to court. So the first one I want to deal with is what is happening to possession hearings and current possession claims. Then, sort of following on from that and connected to that, what happens to existing possession orders, so where you've already had a hearing or a claim, possibly decided on the papers if it's an accelerated short hold tenancy and an order's been granted but the occupiers are still in the property. I'm going to talk very briefly really about accelerated claims, those that can be decided on the paper for a short hold tenancies where there's a Section 21 notice. I'm going to talk and probably spend quite a bit of time about this because I think people are quite interested in this. Other court proceedings that are still going on at the moment, and particularly this idea that's been floated about using injunctions as an alternative to possession claims, which is gaining some traction as a possible alternative. We'll get to it in due course, but it's not really going to work for most landlords and most situations. It's just not really a viable option. I'm going to talk finally then about the changes to notices for possession during the current situation. There have been some changes made to the notice period, as I suspect many of you will know. We'll just sort of flag those up and also highlight a potential problem that some people have identified with the new forms of notices. And why is all of that important? Well, we know really, don't we, what's going on, but just to give a bit of an overview as well about the context. The coronavirus COVID-19 pandemic, as it's been declared, one of the measures that has been taken to try and slow the spread is what's generally called the lockdown. It's formally given effect by the Health Protection Coronavirus Restrictions (England) Regulations 2020, and there are similar for other countries within the UK. And that followed on from the announcement made by the Prime Minister in his televised address on a Monday evening, where he gave his instruction to stay home. The regulations actually are made by the Secretary of State for Health, and the powers given to the Secretary of State for Health rather than the Prime Minister. And it was initially announced that it was for a 3-week period. I actually think the first 3 weeks are already up, but there was a review date enshrined in the regulations, which we are fast approaching. The indication that has been trailed for some time is that the restrictions would not be lifted but would be extended, and what's being, I think, heavily trailed now is that there's going to be an extension for a further 3 weeks. I have to say, I myself would be surprised if that was not the only extension. I think it may be longer than that, but we shall have to wait and see. That's the sort of full lockdown. Even when that goes, whether it is in another 3 weeks or whether it's perhaps in 6 weeks or maybe even a bit longer, there is no prospect whatsoever of everything just going back to normal. There will be further restrictions on what can be done. And as we will see, some of the things that we are talking about are already lined up to take longer than the full 3 weeks. There is then two important things that we're going to look at that give effect to some of these. The Coronavirus Act 2020, the particular bit that we'll be looking at is Schedule 29 to that Act, and that is what changes the notices for possession proceedings. And the civil procedure rules, there is a practice direction, 51Z. Practice direction 51Z is incredibly important to landlords because that is the one that puts the stay on possession proceedings. And as I said last week, and say again today, I think part of the context as well is also common sense about, irrespective of what one possibly can do at the edges of legislative restrictions, there's some common sense, I think, about, well, should you? Is now the right time to be doing certain things? And in particular, I think you have to be thinking very carefully about, even if you can squeeze between the gaps in the regulations and the guidance about, for instance, marketing and then letting a new property, is it necessarily wise to do so, bearing in mind other issues that you might have? Can you get gas safety certificate? Can you give it to the new tenant before they move in? All of these sorts of things. I know it's not great for people's business models, but it may be the hit that one has to take. And various other things where common sense, I think, kicks in. So let's deal perhaps with the penultimate of those first, which is Practice Direction 51Z. And this is the important part of it. All proceedings for possession brought under CPR Part 55 and all proceedings seeking to enforce an order for possession by a warrant or writ of possession are stayed for a period of 90 days from the date this direction comes into force. So that's really significant. And you'll see that if you download the slides in the PDF form, there's a link, and at the end of these slides, I've got a couple of slides where I've tried to collect a series of useful links for you as well.
Robert, can I just mention quickly, there seems to be a bit of confusion as to what the day that this ends is, because they say 90 days, which brings us up to a day in June, but people seem to be talking about September and October, and I have seen that on some of the official notices.
Yeah, so there's a couple of things here. There are different dates being set for different things. So when we come to look at the Coronavirus Act and the change that that has made to notices, that is at the moment running until a date in September, the 30th of September. It is open to the Secretary of State to extend that date. The Practice Direction 51Z is, it's interesting the way it's done. It's 90 days from the date that the direction came into force, which takes us up to almost the end of June. But the practice direction itself says that it ceases to have effect on the 30th of October this year. And I suspect, but don't know for definite, but I suspect that is leaving open the possibility of extending the stay beyond the end of June. But at the moment, the 90-day stay runs out at the end of June. At the moment. So that takes us on really to where we are here. It applies to possession proceedings under Part 55. Part 55, that is the bit of the civil procedure rules that governs nearly all claims for possession. There are very, very few, and really as landlords as private sector landlords, and also I know some of you social housing landlords, almost every possession claim that you deal with is going to be caught by this. It is very difficult to see of anything that would fall outside it and not be subject to the automatic stay. There are some where possession is sort of ancillary to what's being sought. So claims for orders for sale where there's been trust or something like that, which is not really what we're concerned with in landlord and tenant context. They may fall outside of it, strictly speaking. I have to say, quite often, so far as I've seen, courts have been making analogous orders and just staying them under general discretion anyway to match it, because it goes back to the regulations, but also the guidance, government guidance exhorting people not to be evicting other people at the moment. It's really not something that they want to be able to deal with. So that's what's caught, and you'll see just from the bullet point there that possession claims under Part 55, it's pretty wide. It includes a whole host of things. So what is happening to those? Well, as I say, those proceedings are automatically stayed. At the moment, that stay is due to run out on the 25th of June, and so things should start coming back to life after that, unless that date is changed, which it may do. The courts are incredibly stretched at the moment, so there will be some further delay. That seems inevitable. But we all know that it is not beyond the realms of possibility that things might fall through the gap. So if you are concerned, I don't think there is anything wrong or untoward about writing to court at the end of June, early July, and just asking for an update when the claim is going to be relisted or what have you. Let's assume that at some stage, A, this stay does end, which it must do, and B, the full-on lockdown measures are lifted, but we are still in a situation where there are some restrictions. How's it going to work then? Well, we actually have some indication from a message that the Lord Chief Justice sent out on the 19th of March, which is before the full-on lockdown. And at that stage, this is what the Lord Chief Justice, one of the most senior judges in England and Wales, was saying. Judges dealing with any possession claim during the crisis must have in mind the public health guidance and should not make an order that risks impacting on public health. And this one's going to be significant, block listing of possession claims is inappropriate at this time because it would be difficult to maintain appropriate social distancing. Now, at this time, as I say, that was 19th of March. That was before the full-on lockdown came into effect. When that ends and we move into a position where there are still some measures, it seems to me that there will be requirements for social distancing for some time. I think it is going to be very difficult to justify or maintain block listing of possession claims, certainly in the short to medium term, after the stay is lifted. A consequence of that, two consequences really. One, in theory, if you've got to go to court, you should be safer. But two, it's just not going to be possible to get through possession claims as quickly as it was previously. Just follows as a sort of matter of logic, really.
Well, I suppose when we were back in normal times, it was difficult for them to list all the possession claims coming in, and that some of them were listed after the time that they should have been, weren't they? So God knows what's going to happen with this.
Yeah, the rules say that the first hearing should be between 4 and 8 weeks after the issue of the claim. And some areas that was achieved, other areas I think we all know it wasn't. Just as a matter of course, any claim that was issued on, say the 20th of March, just before the stay came in, it's inevitable that's not going to be listed between 4 and 8 weeks, just impossible. But one might hope that it might get prioritised when the stay goes, but of course there's a whole host of things have been gummed up in the works, as it were, because of this. And I think there are going to be some considerable delays for some time to come because the court system has been stretched not just by possession claims or having to deal with possession claims, but a whole host of other types of claims. And I just don't see that it's going to be back up to full capacity anytime soon, because there will be restrictions requiring some sort of social distancing, which are going to be very difficult to keep up. That's I'm afraid there's no sort of good news side to that for landlords, but I think it's better to be honest and acknowledge the difficulties that there are going to be in the future. So that's what's supposed to happen. As I say, these claims should all come back to life after the end of June. If you don't hear something, as I say, I don't think there's anything untoward in writing and asking for an update. Just bear in mind.
We've had a couple of questions in, Robert. Do you want to take them now or later?
Yeah, well, I see a few questions about enforcement of possession orders, which I'm going to come on to. Let's deal with one. I see someone said.